doing things in a certain way or why I'm structuring things. There's a reason, because there's something you don't quite know yet. All right, so let's start by thinking very carefully about the cases for today. Smith and Church of Lukumi. Okay. Who am I up to next? Who is next?
I think it's me, Professor.
Oh, is that Caitlin?
So. Mm-hmm.
All right, Caitlin, so let me ask you a hard question that we're going to spend some time on, but I'm sorry, it's you were up next. Why should people of faith get special treatment under the law?
My personal opinion is they shouldn't, but
okay. Then why not? Why shouldn't they get special treatment under the law? I ask a question that way. I'll flip it on you.
Because we are a country of laws and not a country of religion, and so we need to base our rules based on what is fair for the majority rather than for a select group of people.
So what do we do with the free exercise clause then, which specifically recognizes the right of freedom of religion, doesn't recognize other types of freedoms, but does recognize freedom of religion?
No, I think that's fine. I think the freedom of religion clause is fine. I think just giving certain exemptions because someone claims that their religion states something, it starts to muddy the waters.
So where
do you stop?
So let me ask you a follow-up, Caitlin. Let's just put the courts aside for now, and let's just say the legislature decides to grant an exemption for religion. They'll say generally you can't smoke or you can't do drugs, but if you're Native American, you can use peyote. Do you think in a nation that's not of religion, the government should be allowed to grant exemptions for people of faith? In other words, if you want to do mushrooms because you like getting high, that's not okay. But if you want to use peyote because it's part of your religion, that's okay.
No, I mean, I guess that's the issue in this case, and that's what I had an issue with.
Well, no, it's not. This is not with the legislature. This is with the courts. We'll do legislature later.
No, I understand what I'm saying. Is that it's difficult because.
Ooh, okay.
You want to give them their freedom to do that because it's the law, but at the same time.
Why should they be privileged? Why should they get an exemption for the law that other people don't? If I want to smoke, use a narcotic for just like getting high versus doing it for a religious reason. Okay, thanks, very good, Caitlin. Yeah, it's okay if you're not certain. That's fine. Alexandra, are you here?
Yes, I'm here.
I'll ask you the same question I gave to Caitlin a minute ago. Why should people of faith receive exemptions from the law, or maybe they shouldn't at all? And forget the courts. Let's just talk about legislature, right? We forget the courts for a minute. We'll get to the courts later.
Well, I guess why they should is because there's always the fear of like religious persecution. I guess you could make a law or you could get in trouble for doing something maybe not entirely invalid, but still like use the religious justification, I guess.
But what's wrong with the government saying, you know what, religion's nice, but we're not giving any exemptions? You know, if you want to, if you don't want to work on the seventh day, you don't have to, right? But no one's going to force you, right? Or, if you want to be a Native American, that's fine, but we're not giving you an exemption for peyote, right? Why should religious exemptions be granted at all? Forget the courts, just the legislature.
Because you should be free to practice what your religion.
Why? You said you should. I'm asking why. That's the harder question.
Because I feel like it gets limitless if you don't let somebody.
Why?
Like that's kind of
why
within their rights.
Why? You keep telling me, stating a thing. Why? Why should we protect this? Why is it problematic? What's special about religion?
I guess it's kind of like historic back in England.
Okay.
Yeah.
What's the history there? Tell me.
I mean, Christianity was a very big part back in I guess the founders' days. I don't know if it was
was everyone Christian?
No.
Some people maybe weren't Christian. What happened to them?
They were persecuted.
Mm-hmm. So what's this? Why is religious persecution necessarily bad?
I don't know. Those are hard. I mean, because I feel like it's just a big continuum. Why isn't it bad?
Brianna, are you here? Brianna G? All right. Let's go further down the rabbit hole. Why is religion important at all?
I feel like it's important to those that believe because it gives them a sense of comfort. I don't know.
So is it like having a blanket or something? Having a,
I feel like having something to believe in is kind of stronger than, for your example, a blanket. It's just something.
Why is religion special? Why should religion have any special place? Let's say we didn't have the First Amendment, right? The First Amendment was never ratified. Why would we as a society today decide to provide any protection for religion? Starting a new country tomorrow, right? The Republic of Brianna, right? Why would you, if you're writing a constitution, why would you provide protection for religion in today's climate?
Because if I didn't, I'd be restricting the freedom of my people because you may believe, you may not believe, but the choice is yours.
Right, but there are lots of freedoms you can protect. Not every government around the world is protection for religious freedom. There are plenty of nations, I can name them, you would know them, that don't have express protections for religion. Why would you put that in your Brianna Republic Constitution?
Is the answer not in the Brianna Republic, but is the answer in general just because this is America and the freedom of
I'm asking from starting from first principles. Why is it important to protect religion? Oh man! All right, Jessica, you here?
I am.
The Republic of Jessica. Okay. Why are we protecting religion, or maybe we're not? Maybe in the Jessica Republic we don't protect religion. You tell me.
Well, I think first of all, religion is deeply personal, and that's and it's spiritual, and nobody really knows. Although I know a lot of religious people who tell me that they do know. I don't know if anybody specifically knows, and so I think it's hard. You have a lot of competing interests with religion and tiny sects. If you think of the formation of America, the people who came here, their beliefs, they were all Christian, but some of them believed in just the pure Bible, and they thought the Puritans, the separatists, you have the Quakers, all these people came together here, and basically everybody had variations on the same theme, right? So I think it's hard to, I think that's one issue. And I think
I'm not talking about 1776. I'm talking year 2021. You form a republic tomorrow.
So I think it's deeply divisive. And I think that there's today it would be hard because I'm not sure there's an actual majority that would be the designated oppressor. So I'm not sure which ones would you pick? The Baptists?
I'm not asking you to pick a religion. I'm saying why is it important? Would it be important to protect any religion in general? Today?
I think because it's deeply personal and spiritual, and it's so incredibly inflammatory. It is important because I think it keeps unity among the people. It keeps people from fighting over something like that. Personally, I mean,
what keeps people from fighting? Having religion protected or not having it protected? I don't understand.
Having religion protected, I think, keeps people from fighting. If you can do your own thing, you don't have to go fight for your religion to come out to be appreciated. It's okay. You're allowed to believe in reading the Bible. You're allowed to believe in going through a priest as your conduit. You're allowed to do it. We don't have to have any wars over that. We can worry about other things that we have to focus on.
All right. Thanks, Jessica. All right. I like asking this question. It's a similar question to when I ask when we do the gay marriage cases, like, why is marriage important? And people always say love. And the answer was not love. That's not why marriage was important. It was important because it channeled people to have children in a responsible fashion, right? But that's an answer that people today just never think about. I'd wager that of the 90 odd people on this Zoom list, most were like, oh man, I don't know the answer to Blackman's question, right? You're struggling. And Caitlin and Alexandra and Brianna, and I think Jessica gave me very strong answers. They gave me very thoughtful answers, but there's a basic threshold issue here that most people never think about is why protect religion. Now, I take Caitlin's point quite well. She says we shouldn't, right? It's something that our society shouldn't protect. That people should not be able to get exemptions to the law because of their, I think she said supposed or some such word of beliefs. And then I think Brianna gave a different answer, that this is something that provides comfort to people. And I think that's also a very fair answer. Jessica spoke of spirituality, which I think is also a fair answer. But none of these points would tell you the basic question. If we were starting a constitution from scratch, why would we provide protection for the free exercise of religion? Like, why? Why in general should religion ever give some people privileges that non-religionists wouldn't have? Like, if there's conduct X and that conduct is motivated by religion or motivated by something else, why would the religious motivation allow some protection, whereas the non-religious motivation would not? And that's the question we have today in both Smith and Lukumi, right? If someone went to court and said, I want to use peyote because, I like it, it gets me high, I don't think most people would have much sympathy for that. Of course, maybe if you think legalize everything, right? Screw it. I suppose that argument would work well. But if we believe that there's a religious motivation, why does that change the situation? In the second case, in Lukumi, it may be a little bit easier because this is what I think Alexandria called persecution, right? You're targeting one faith. Right? So the targeting cases, I think, tend to be a little bit easier for people to grasp. But the non-targeting cases like Sherbert or Smith are harder. All right. Jessica, you have another point you want to make?
Well, I think it was, when reading Smith and comparing it to Sherbert, I guess the fact that Sherbert's real violation was that she just didn't feel comfortable working on a certain day of the week, which was not something that was prescribed to keep society safe.
Right.
I didn't think they were really truly comparable situations.
Well, that's what Scalia says, and we'll get to that point a little bit later, I promise. I want to do some groundwork first. All right. So before we get started, Christina, are you here? Were you able to sign on?
Yes, I'm here.
Okay, very good, Christina. Do you want to talk for a bit about peyote? I know you emailed me earlier. You said you wanted to just talk about it, so I'm happy to call on you.
So I guess just background information, because I don't know if a lot of people have this kind of background, but I'm Native and my dad has his NAC membership card. And
that's just a Native American church, if you know what NAC is.
Yes. And so peyote is very sacramental, and it's not used. Western stuff. And it's not used to get high. It can be in a mush form or tea. And I guess when I say it's not meant to get high, it's like the purpose. It's very guided. It's very structured, and it's within a ceremonial setting. So that's really all I had to say.
Okay, thank you. I appreciate that background. I had a Native student a couple of years ago who had done it himself, and he told me this was not stuff you want to get high off of. He said it was a very unpleasant experience. He said he was like vomiting and throwing up, and like the first time it really hit him hard. Like it was. I think he said he became violently sick and ill. Is that, Christina? Is that what you've heard?
Yeah, that's what I've heard. Especially when I guess you don't take it often. Yeah,
it was his first time. He just tried it at a ceremony, and he said he was sick. It didn't sit well. So again, this is not like a recreational drug. I didn't mean to say that, but maybe substitute peyote for mushrooms, right? There are things that people do take that would get them higher in the same category. I had a classmate in law school who grew them in his closet. I don't know how that stuff even works. Whatever. The things people do. All right. So let's talk about Smith. Who is next? That was Dusty. You here? Dusty? Well, Christina, by the law of the alphabet, you are next, actually. So if we want to give me the facts in Smith, I'm sorry. It was completely not planned, but you are next.
Yeah, sure. So Smith and Black, they were fired from their jobs after consuming peyote. And then once they applied for, I guess, unemployment compensation, they were ineligible because their firing was based on misconduct. So that's the basis of the First Amendment claim.
Okay, very good. Thank you, Christina. All right, so I just mentioned this point, but Smith and Black were actually drug counselors. And they have at least Smith, I don't know much about the other guy, but Smith had a pretty fascinating story. He had serious alcohol and drug abuse, and later in his life, he came to his faith, and it really put him on the straight path. And it got him sober, which is, I think, there's a high degree of drug abuse among Native people. That's just it's very prevalent. And he became a drug counselor, which I think is an admirable job. It's not easy work at all. And he lost his job because he was using peyote. And, you can imagine the boss saying, how can I keep you on as a drug counselor when you're doing controlled substances? And he's like, look, this is not a recreational drug. This is part of my religion. So you can just, you can imagine how the situation would have gone down. But he lost his job, and then he went ahead and applied for unemployment benefits. Now, the first point, who's next? Sienna, you here?
Yes.
Okay, Sienna. The first point is actually what Jessica was getting at before, and I want to address this. How do we reconcile Justice Scalia's opinion with Sherbert? By the way, Brennan dissented vigorously here. He was in dissent, so he didn't think these cases lined up, right? Brennan, he didn't like it. But let's just try as best as we can. How do we reconcile, Sienna, Smith and Sherbert?
Guess I'm not entirely sure.
Oh, this is a huge question. If you don't know this, you didn't read the case closely enough. It's a huge issue.
Okay.
Okay, I'll move on. Victoria?
Yes, sir.
How do we reconcile Smith and Sherbert?
Well, I think it was, the big thing was that this was a generally applicable law that they were like trying to prohibit the use of controlled drugs, and in Sherbert, they weren't trying to prohibit her observing the Sabbath on a Saturday.
Okay, I think that's very good. I think that's very close. Let me just unpack a few things. Technique, you gave me a couple good answers there. You said in Smith we have a generally applicable law. What does that mean, a generally applicable law? It's a very important term to use. I want to make sure everyone understands what that means.
That it applies to everyone evenly. It's not targeted toward a specific person or action.
Okay. Good. Victoria, what was the unemployment scheme in Sherbert generally applicable?
Yes.
It was. So you're on the right track. Okay. So in both Sherbert and in Smith, you had generally applicable laws. So both neutral, right? The employment law in South Carolina wasn't targeted at Seventh-day Adventists, and the employment law in Oregon was not targeted at Native Americans. We can all agree on that. These were laws applied across the board.
Mm-hmm.
But the second thing you said is actually correct. What is the difference between the activity at issue in Sherbert and the activity at issue in Smith?
Observing the Sabbath on a particular day versus the use of controlled substances.
Is observing the Sabbath a crime?
No.
Of course not, right? Of course not. Is using a peyote, a controlled substance, a crime?
Yes.
Okay, all right, excellent. All right, thank you, Tori. So you can reconcile, I think, Smith and Sherbert very easily for the reason Tori just told us. Smith involved a illegal act that is using peyote, and Sherbert was an act that was completely normal, right? Going to church on your Sabbath is, that's not a crime. Okay. If that was the only ground of conflict, then I don't think we'd have much of an issue. But Smith seems to do more than just sort of distinguish itself from Sherbert, right? Smith buried Sherbert, right? It didn't quite overrule it, but I think Smith limited Sherbert to a very narrow set of facts. And let me try to explain this. This point's a little bit complicated because, look, usually Scalia is very clear. right? Usually when Scalia writes, you know exactly what he's saying, except when he needs Anthony Kennedy's vote. When Scalia needed Kennedy's fifth vote, he's got very fuzzy, right? It's the worst. The worst is when you have a Scalia opinion that needs Kennedy, Heller, right? It's just the worst because it just waters everything down. So here, Scalia wasn't as direct as he usually is. But let me try to explain what's going on here. When you have an unemployment compensation scheme, right, it's very fact specific, right? When you apply for benefits, you have someone in the government who looks at your case and decides on a case-by-case basis whether you meet the qualifications, right? There are some broad guidelines, but it's very fact-specific. So in the case of Sherbert, her specific situation was that she was willing to work on Saturday. I'm sorry, she was willing to work on a Sunday, but not on Saturday. That wasn't something that was provided for by statute, right? It was just a very specific, unique situation, right? In contrast with Smith, there was a bright line rule. If you were fired for breaking the law, you didn't get benefits, right? That's a bright line rule, right? If the grounds for your termination was use of some sort of drug or something that's criminal, you lost it. So in Smith, there was really no discretion, right? The government was basically required to deny benefits because of the the use of the peyote. In Sherbert, there was some more discretion. There was like an individualized determination. What Scalia suggests is that unemployment insurance is unique because everything's done on a case-by-case basis. So you have this case-by-case basis, right? You're allowed to sort of use the Sherbert test still to this day. But when you have sort of a bright line rule, you go to Smith and you think, Josh, that doesn't make any sense. Yeah, I'm with you, right? Scalia drew that distinction because he didn't have the votes to overrule Sherbert. If Scalia had the votes to overrule Sherbert, he would have. He didn't have the votes. He needed Kennedy. It was 5-3 or 5-4. Okay? Right, so the court in Smith did not have the votes to overrule Sherbert. So Sherbert still exists to this day. And Sherbert exists in cases where there's some sort of individualized assessment, right? Lukumi would give some more insights into what that means, like in the next case. But at least in Smith, Sherbert stayed on the books. It wasn't overruled entirely. So let me try to break down where the law was in Smith, right? If you had a law that was generally applicable and neutral, right? That's where Torah used. If you had a law that was generally applicable, that burdened religion, you review the law with a rational basis standard, right? This is what Scalia explained. If the law is generally applicable, right, you review it with a rational basis standard. If the law is not generally applicable, that is, some sort of individualized assessment, then you go to something closer to strict scrutiny or even beyond strict scrutiny, right? If it's not neutral, right, or if it's not generally applicable, there's some sort of case-by-case basis, right, where House of Worship A gets one treatment, but House of Worship B gets another treatment, right? Then you're back in Sherbert land. And you have this sort of super strict scrutiny test, which is what they use in Lukumi. So the key threshold question is one that Tori gave me a minute ago. Is this a law of general applicability, or is it based on some sort of individualized assessment that's based on religion? Right? That's not exactly what Lukumi says. Lukumi would sort of add on to it because Justice Kennedy wrote his opinion, but that's at least how the law existed in Smith. So you have this broad rule that maybe Caitlin would like. This was Caitlin's rule a minute ago, right? Where you can have whatever thoughts you want, but if the government decides to ban it, you don't get an exemption because of your religion. Scalia brought us back to the Mormon case, Reynolds, right? That's why I put so much time to it, because if you understand Reynolds, you understand Smith. They're the same case, really. a person was seeking an exemption from a criminal statute. It's close enough, right? Based on religion. And the court said, that's nice of your religion. We're not going to do it. If the legislature wants to give you an exemption, they can. And in fact, in the wake of Smith, many states did create carve-outs for controlled substance laws for Native Americans. Right, so the legislature was able to give an exemption. But don't come to the courts for one. Right, because think about it. What Smith wanted was not for the Oregon legislature to make an exemption. He wanted the courts to use the First Amendment to create an exemption to a state law. And Scalia said, absolutely not. Not going to do it. All right. Any questions on the Scalia opinion? Yeah, again, I think you can reconcile Smith with Sherbert. I absolutely think you can, but I think we should be candid and say Scalia was basically overruling without saying so. He narrowed it to a very limited set of facts that, frankly, are hard to find because the government can usually get around it. Questions on Scalia? The dissenters were not happy. You had dissents from O'Connor and Justice Blackmun, no relation. And they basically said, look, you're killing Sherbert, right? They said, and I think they're right, and Brennan joined both dissents, so he would know what he's talking about. I think this was his last term on the court, too. He was quite sick at this point. He was holding on for a Democratic president. He couldn't quite make it, and he stepped down with H.W. Bush. He just could not make another year. So I think he was towards the end of his career, but he recognized what was going on here. And O'Connor writes that this departs from our First Amendment cases, and it shouldn't matter if the law is generally applicable. Okay. Another related point is that if you leave religious exemptions to the legislature, majority faiths will get exemptions, but minority faiths will not. So to use an easy example, during Prohibition, where alcohol was banned, there were exemptions made for sacramental wine. You know, when you take the communion, right, to take wine. Majority faiths will get exemptions, minority faiths will not. So you're going to get an exemption for Catholics drinking wine, but not for peyote. I'm sorry, Native American church people using peyote. Okay. But Smith became the law of the land. All right, questions about Smith? Questions about Smith? Smith became very unpopular, at least in some quarters. And a couple years later, Congress enacts a statute, which you probably read about in common law, called RFRA, the Religious Freedom Restoration Act. Did you do RFRA in common law? People are okay. RFRA is a Religious Freedom Restoration Act. As the name suggests, it's trying to restore. What RFRA tried to do was to bring back the Sherbert test, kind of, and the precise details are fuzzy. But RFRA tried to bring back the compelling interest test from from Sherbert. The Supreme Court kind of said, no, you can't do that. So as things stand now, federal laws are subject to RFRA. So if you sue the federal government for violating your free exercise, you can rely on the statute. And the federal government must comply with basically the Sherbert test to decide whether the free exercise clause has been violated. Many states, including Texas, have adopted RFRAs. So if you sue the government of Texas for violating the free exercise of religion under the Texas state constitution, you're in Sherbert land. So as a practical matter, Sherbert exists for federal government challenges and in about 20-something states with RFRAs. But not all states have RFRAs. California and New York, they don't have them. So in those states, when you sue the government for violating religion, you're stuck with Smith. At least for now, and I'm just going to give you a tease for class on Wednesday. There's a case pending at the court as we speak called, Fulton v. City of Philadelphia. We'll talk about it on Wednesday. But there's a direct call to overrule Smith. I don't think the votes are there, but who knows what's going to happen. I don't expect if someone's going to ask me, Josh, what happens if Fulton's decided before the exam, I'll let you know. I'll definitely tell you with the day that's decided, but I will probably just say limit yourself to what you learned in class. I remember when I was in law school, there was a Supreme Court decision decided in the morning, and I wrote about an exam that evening. I was a weird student. It was an admin law case. It was Fox versus FCC, where Bono, who was a musician, went on some TV show, and he said, this is fucking great. And, he had a complaint against him for cursing on TV. And then that was a case aside. I wrote about that evening on an exam, but I won't expect that of you. But Smith is not in stone. Justice Scalia is gone. I don't know if Justice Barrett, his former law clerk, would vote to rule it. We'll see. I'm not optimistic. I don't think she would. But Smith is not a popular decision among conservatives. In fact, it's almost surreal to think that Justice Scalia would write a decision that would be so hostile to religion. We'll talk about why that became the case for Wednesday. I just want to tease it for now. But yeah, definitely read the materials for Fulton. It's an important case. Or it might be a dud. Supreme Court usually ducks in these issues. They might find out some way of avoiding the question because they're a bunch of cowards. They don't like deciding anything. They always do. Okay. All right. Questions on Smith. All right. Let's do Lukumi. This is another case that, I think there's a pretty broad consensus that what happened here was bad. This was a 9-0 case. This wasn't 5-4. This was 9-0. All right. Who's next? Allison, you here?
I'm here.
Okay, Allison, do you want to give me, please, the facts in Lukumi?
Yes. So this was a minority religion that tried to move into a city,
Hialeah, Florida. It's outside of Miami. Yeah. South Florida.
And,
where all the spring breakers are right now.
And a part of their religion was sacrificing animals for certain things, including like weddings or if they were sick and things like that. And the city people didn't really like it. And so they went to city council and they enacted a couple of different ordinances that pretty much made what they were going to be doing illegal and to block them from practicing their religion in the city.
Okay. All right. Very good, Allison. Thank you so much. Is there anyone here that's either a member of the Santeria faith or has ever been to one of their temples who knows about them, who wants to say a few words? Anyone? No? Okay. So this is an Afro-Cuban, I never say this word right, syncretistic, where basically different types of faith are sort of synchronized or merged, that merges African and sort of Caribbean beliefs. And one of the tenets of this faith was animal sacrifice. And I give you guys the videos, right, for these cases. I thought very long and hard when I made this video, do I put an actual video of the ritual? And I decided against it because I thought people would be too squeamish. But if you want to Google it, you can Google it. It's not for me, right? Who am I to judge? But the blood and the chickens, and it's just not for me. So I didn't put in the video. I thought that would just be distracting. But I thought about it. I kind of just alluded to it. Now, in the abstract, animal slaughter is a potential health issue, right? You remember from common law, these slaughterhouse cases. Remember that one? Yes, going all the way back to 1873, if memory serves. Might be off by a year or two. The issue of sanitation is not a joke, right? When you slaughter animals, there's blood, there's potentially bacteria, there's parasites that come on the carcass, right? There's bugs. It's a legitimate issue to have slaughtered animals if it's not being done in a clean fashion, right? We all agree with that. But we ask ourselves, was this law enacted to promote animal hygiene? Or was this law enacted for other reasons? So, okay, that was Allison. Matthew, you here?
Yes, sir.
All right, Matthew, so help me out here. The first question we ask ourselves from Smith, is this a law of general applicability?
No.
How do you know that?
Well, I mean, the facts of the case, it's super targeted. I think they actually called like an emergency meeting after they got like all the land approved. So it's just very specific.
Well,
targeted.
hold on, Matthew. Let me just stop. When I say general applicability, am I looking at the face of the law, just the text of the law? Or am I looking at something else?
I think you can look to the face of the law and the effect of the law.
Whoa, hold on. This is where Justice Kennedy blew up another area of common law, right? I thought reading Smith that with this neutral and general applicability, we're looking at the face of the law. So let's just stay with the face of the law. Is there anything in the actual ordinance, right, the text of itself, Matthew, that suggests this law is not of general applicability? Before we get to all this other stuff, the emergency meetings, this other stuff.
I mean, I don't think they come out and say like no Santeria. So I would say it's probably not.
Well, does the ordinance use words like sacrifice and ritual?
Yeah.
So is this on its face generally applicable?
I mean, I don't think there's any other religions that are sacrificing animals in there.
There you go. All right. Thanks, Matt. All right. So before we get to Justice Kennedy's, sort of extrinsic evidence, I'll call it, let's just focus on the statute itself, right? It talks about sacrifices and rituals, right? When you put those sorts of words in the damn statute, you're probably going to violate the First Amendment, right? That's just a general rule of thumb. If you have to mention the name of the religion or the religious ritual, you're probably having in your mind, okay, how do we go after this one thing? Genevieve, you here? Genevieve?
Yeah, I'm here. Sorry.
That's okay. So Genevieve, this is what we call the stupid staffer test. There's a Scalia made this phrase, the stupid staffer, right? Only an idiot would put these words in the statute, right? If you were, you're a smart law student. If you were advising the city of Hialeah, how would you have perhaps written this ordinance differently? Would you put the words ritual sacrifice in there?
No.
What would you have put in there, maybe?
You would have just made it more broad language because they're being super under-inclusive with it.
Ooh, oh, good. Oh, you answered my next question. What's this under-inclusive business?
So they're just talking about, because it's talking about certain type of conduct that deals with killing, and it's something that the religion specifically does, that they could have made it more broad, but instead they're choosing exactly what this religion does.
Exactly. They're choosing exactly what this religion does. Thank you so much, Genevieve. Right. So if you were not a stupid staffer, right, if you were smart, you would just say, how about there's no slaughtering of animals unless it's being used for food? How's that? Right. That sounds pretty good. No slaughtering of animals unless it's primarily used for food. But wait a minute, though. What about people who are taxidermists, right? They want to stuff the animals. Okay, well, so no slaughtering the animals unless it's being used for food or for taxidermy. Okay. Oh, but there's some people who might slaughter animals for fertilizer, right? Because you can actually chop up animals and use it for fertilizer, as people do. Okay, so no slaughtering animals for food, taxidermy, or fertilizer. Okay, now you see the problem, right? You're basically allowing everything in but the religion. So Genevieve mentioned under-inclusiveness. You also have the problem of over-inclusiveness, where if you make it that everyone can kill animals except for the Santeria, you're in trouble. So let's just focus on the text by itself, right? Oh, Gavin just answered the second question in the chat. Okay. Let's just focus on the text itself, but you can use over-inclusiveness and under-inclusiveness. Now, Marcus asked a good question. He said, weren't they eventually in? I said primary purpose. I think I was careful with my words. If I wasn't, I apologize. But the primary purpose was for food. But the word primary might be over-inclusive, right? Why are you letting in all these other things but not religion? So it's hard to to use the phrase to gerrymander or gerrymander, if you will. It's actually it's with a G, hard G. It's like GIF, whatever, right? To gerrymander around religion, right? You're basically drawing a line around this one little practice. So the court finds this is not neutral. It's not generally applicable. Therefore, we go to strict scrutiny. This is basically the Sherbert test, right? We're back in Sherbert land. It's a targeting law. It's targeting religion. And this is not narrowly tailored, right? If they wanted to draft a statute, they could impose some sorts of hygiene requirements, right? They could say they have to, dispose the blood in a certain fashion, and they have to ensure that there are no parasites, right? There are ways that you could write the statute. Although let me pause for a minute. What about monitoring, right? Are you going to send in health inspectors to watch these rituals to make sure that they're doing it properly? It's actually a very hard question, how to enforce these sorts of laws against religious institutions, which is why perhaps Caitlin's first point was, don't give them any exemption, right? Are you going to let these people exempt from health codes that they're going to have these imagine after every Sunday ritual, they put a huge tub of blood on the sidewalk in front of their church, wait for the sanitation worker to pick it up in the hot Florida sun. People are nodding their heads, right? Look, the blood's got to go somewhere. Do you pour it down the drain? Do you pour it into the sewer? I mean, there's problems with that also. It's not clean. There's guts in there, right? There's stuff, right? When you have an actual slaughterhouse, they have very elaborate protocols to dispose of animal waste. But there's one other issue that Matthew mentioned. I sort of wanted to push him away. I'll come back to it now. Is the history. Look, this bill was enacted in a freaking panic, right? These people found out the church was opening up, like, oh my God, we can't have these people in our neighborhood. Let's write a statute directly exactly to them in an emergency fashion and rush it through like in 5 minutes. Okay, thank God he's off the court. But if you want to piss off Justice Kennedy, do this, right? If you want to make yourself lose to Justice Kennedy, it's pass a statute targeted at a specific group in a very small period of time. This is like an automatic 9-0 loss when you do this to the court, right? You should not be targeting one specific faith. And it was very obvious. The lawyer for the city did his best. I listened to the argument. He's like, well, look, we have a health condition, right? How do we deal with this? Draft a statute designed for the health concerns, not to make it illegal to practice their religious ritual. Lukumi is still good law. And every now and then people make successful targeting challenges. Although usually you don't have stupid staffers, right? People in government are smart enough to know not to do this, right? Usually, governors don't come out and say, we are passing this rule because we're really worried about this one religious group, unless you're Andrew Cuomo, right? Usually, people, government leaders don't come out and say these kinds of things because they're smart enough not to. Okay? All right. Questions on Lukumi. It's a very important case that comes up a lot. It's hard to make the case for targeting. Yeah, Ryan, go ahead.
So here we had a case where the specific faith was being targeted. And so, it was pretty clear there. What about faith in general? What about general things that carve out all, somehow books of worship must be sprayed?
How about all houses of worship must close during COVID? How about that?
Exactly. So yeah. How does, I'm assuming we'll talk about it, but, how does that kind of shake out?
Yeah, ask me in class on Wednesday. I will talk about that. I promise. I don't have time to do it now. Okay. Yeah, that came up in COVID big time. Yeah, I mentioned Governor Cuomo. I'll come back to him in class. I'll tell you by the time he threatened me over the phone. It's true. Happened. All right. Who's next? Oh, someone's clapping. You're clapping at Cuomo or clapping at me? I'm not sure. All right. Thanks, Reed. All right. Other questions? All right, let me wrap up a bit, and I'll let you guys out of here, and then I'll start the minute polls shortly. With the free exercise of religion, we have this very foundational question. Should belief get you out of jail, so to speak, right? Should conduct motivated by religion be immunized from the civil laws of the country or the criminal laws of the country? Most everyone agrees that targeting is bad, like in Lukumi, right? I think just about everyone here on this call, Caitlin, I think from top, sorry, you were first up, I can't come back to you, but everyone would agree that Lukumi is probably a bad idea. But the difficulty is when you have a neutral law, a general law that's not targeting, should people faith gain an exemption that other people will not get? And these are not easy questions. Fulton, I think we'll get some sparks flying. We'll see what happens there. But this is a case that's live now. And whenever a case is, when a case is decided, it's like, all right, whatever, that happened 10 years, I don't care. When a case is live, I find students get very animated about it. And I always try and get at least one pending case per year for common law or First Amendment when there's a relevant one. I always try to have a pending case because it's much more, there's something still to argue about. All right, guys. Excellent class. I think you all did wonderful today. It was a very thoughtful discussion. I'm grateful sincerely. And I'll see you all for office hours in about 10 minutes. Otherwise, we'll talk on Wednesday. Thank you so much.
Professor?
Yeah.
Hi. So I just wanted to let you know this isn't about class, so people can if they want
No. Just sign back in a minute. I don't want to disturb everyone. All right. Thank you.
Okay. All right.